Hello, everyone, and welcome. My name is Jennifer Hewer. I'm the Managing Director of the Center for Health Policy and Law, and it is my great pleasure to welcome you to today's virtual event. I'm thrilled that we were able to One moment. I'm thrilled that we could co-host this event with Northeastern University Center for Law, Information, and Creativity, as well as the Center for Democracy and Technology. We actually started talking about hosting this event last spring when our colleagues and Lydia XZ Brown, a Northeastern alum, reached out to tell us a little bit about some of the amazing work that they've been doing. And we thought, well, just how great would it be to host a forum like this to tell everyone a little bit more about it. And so here we are. So I'm just beyond thrilled. Today, we're going to talk about the risks and harms that data-driven practices can cause for disabled people. We have a wonderful set of panelists who will be joining each other in conversation, and then we will follow it up with what we hope will be a robust question and answer discussion. Before we begin and I introduce some of my colleagues, I did just want to mention a couple of housekeeping notes. One, we do have accessibility for this event. We have captioning services, and we also have interpreters. Feel free to flag. You may send a chat in the chat function, or you can just directly chat myself. You can pin the interpreters as well. We are live streaming and recording this session, so it will be made available to the general public on our website and the Northeastern University School of Law YouTube, and also the Center for Democracy and Technology website after the event. We invite you all to walk around if that is what happens. Feel comfortable in your space. This is a Zoom session, and so especially if folks have this event on gallery view, we just want people to feel comfortable in their space. Nobody will be distracted or anything like that, right? So enjoy and do what you need to do to be able to engage and listen in on the conversation. We do have the chat function open. As I mentioned, we will have a question and answer period. Feel free to use the chat function if you want to post questions that come up as we go along with the event. But we will also, so somebody will be monitoring that so that we can pull from those questions for the discussion. And then, of course, during the discussion, you're also welcome to post any questions you might have then. And you're more than welcome to ask us if you need any assistance along the way. So I think that's it on my end. Again, welcome. So excited you could join us. We're just thrilled to host this event. And now I'd like to hand it over to my colleague, Nasser Redress, Managing Director of Northeastern Center for Law, Information, and Creativity.
Thank you, Jennifer, and welcome everyone to our panel discussion today. I'm not sure if you know, but today is actually Data Privacy Day, today, January 28th. So I think it's especially important and relevant, and I'm glad we are having this discussion today. Public and private entities use data-driven decision-making to more easily or efficiently distribute benefits, opportunities, and protect the public. These practices can turn out to be very data hungry, and the wealth of data collected can enable entities to make improper, unjust, or even explicitly discriminatory decisions based on data that may not even be relevant to the purpose at hand. The extensive data collection is, for all intents and purposes, a form of surveillance, and it's not limited to any one context. It includes data collected through the administration of Medicaid and other public benefits, from devices used with medical professionals as part of a treatment plan, and from commercial wearables and health apps. It also includes technologies to monitor workers' online activity, their movement, their surroundings, their conversations, and even their productivity. It further includes practices to surveil students through remote learning and proctoring, attentiveness monitoring, and also for behavioral and academic intervention and other school threat assessment. This can often also result in police involvement. And finally, the tools used in the criminal legal system by law enforcement, prosecutors, and the courts, and also probation. These tools are used directly and by private entities to involve law enforcement. So today we're going to dive a little bit into these surveillance practices and how they affect data-driven decisions and how the data practices across these contexts are interconnected. With that, I'm delighted to introduce today's panelists. Tina Smith-Nelson is a managing attorney with the AARP Legal Counsel for the Elderly, where she manages civil litigation on behalf of DC seniors within the economic and healthcare security practice, which encompasses 5 projects: public benefits, the Veterans Advocacy Project, the Homebound Elderly Legal Project, probate and estate planning, and self-help offices. Tina served in past leadership roles with the DC Consortium of Legal Services Providers. And prior to joining LCE, Tina was investigative counsel with the Office of Inspector General Legal Services Corporation and supervising attorney with the Maryland Legal Aid Bureau, Inc. As adjunct professor, Tina taught classes and seminars at the Howard University School of Law, the University of Maryland School of Law Summer General Law Clinical Program, and Montgomery College. Thank you for being here today, Tina. Emily Paul is a project director at Upturn, where she focuses on the harms of policing technology and the use of algorithms in public benefits, particularly in Medicaid LTSS, that's long-term services and supports. She was previously a 2019 Tech Congress Fellow in the Office of Congressman Mark Takano, where she drafted legislation on the use of algorithms for forensic analysis in the criminal legal system. Prior to Tech Congress, she was a user experience researcher at Salesforce, where she conducted research with customer service workers to inform the design and development of Salesforce's customer service software. She lives in the Columbia Heights neighborhood in Washington, D.C., where she organizes with her neighbors against evictions and to share and redistribute resources through mutual aid. Damien Patrick Williams is a PhD candidate in the Department of Science, Technology, and Society at Virginia Tech. Damien researches how technologies such as algorithms, machine learning, biotechnologies are impacted by the values, knowledge systems, philosophical explorations, social structures, and even the religious beliefs of human beings. He's especially concerned with how the knowledge and experience of marginalized peoples affects the techno-social structures of human societies. Damien is a member of the Project Advisory Committee for the Center for Democracy and Technology's Project on Disability Rights and Algorithmic Fairness, Bias, and Discrimination. And more of his research can be found at afutureworththinkingabout.com. Lydia X.C. Brown is a policy counsel with the Center for Democracy and Technology's Privacy and Data Project, focused on disability rights and algorithmic fairness and justice. Their work has investigated algorithmic harm and injustice in public benefits determinations, hiring algorithms, and algorithmic surveillance that disproportionately impacts disabled people, particularly multiply marginalized disabled people. Outside of their work at CDT, Lydia is an adjunct lecturer and core faculty in disability studies and women's and gender studies at Georgetown University. They're also a NUSL graduate, a Northeastern Law graduate from the class of 2018. Thank you all for being here today. Emily, we'll start with you. What kinds of public benefits programs do data-driven systems use? What role do these systems play in the benefits decision-making process? What kind of data do they collect for the decisions they are trying to make?
Thanks. Yeah, happy to be here. Hi, this is Emily. So really every public benefits program uses data to administer benefits and collects data to do that. So, if you think about anything from public housing, SNAP, food stamps, Medicaid long-term services and supports, supplemental security income, and the list goes on. In our work at Upturn, we found it useful to differentiate between two kind of main buckets of types of systems or functionality. So if you think about kind of basic logistical functions, like having an online application, doing data matching, pulling in some kind of information from another system, that's all a more kind of logistical function of the technology. And then we also think about the more discretionary, what we usually think of with like algorithmic decision-making. So enforcing or measuring eligibility requirements or fraud, or deciding how much support does someone get from a program like LTSS. And so both of these are important forms of data collection and use that have some different kind of implications for what are we going to do about them when they are restricting or denying people's access to benefits. So, and one thing I want to say, especially with the measurement or discretionary stuff, is in the US, we have a very benefits programs that are rooted in ideas of scarcity, of who's deserving, of like limiting people's access to benefits and making sure that nobody who doesn't absolutely need them along the definitions that have been established gets benefits. So because of that, there's all this infrastructure to enforce that means testing and that measurement. And a lot of that is very discretionary. But even the logistical things, like basic things about an online application or matching your name from one system to another, can go wrong and can cut people's benefits or deny them. So I want to share two examples to illustrate like these different kinds of issues. So one is with supplemental security income, which is, a monthly support for elderly and disabled low-income people. And there's, first of all, policy-wise, there are very restrictive resource limits to be able to receive these benefits. So you essentially have to remain impoverished in order to receive these benefits. That's a policy problem. But one technology problem that happened with SSI is that the Social Security Administration was doing automatic checks of people's bank accounts to see, are they exceeding these asset limits, which are $2,000 for a single person and $3,000 for a couple. Maybe that changed and someone else here knows the current numbers, but roughly. And what they did was they built a system that would, if the first day of the new month fell on the weekend, they would deposit the money early. But then they would check people's bank balance. And if they had money there, they would flag them as having too many resources when they had received their benefits early from this same agency. So this was just like really badly designed technology. If you're building a system, you're programming it to deposit things early, and then you're also programming it to check and flag and cut people's benefits based on them having those benefits there. That's just bad tech that is also making a already bad and harmful policy even worse. So many people lost their benefits. There was a class action lawsuit. Eventually, they fixed the issue at last, as I know. If anyone else here knows more of the status, please chime in maybe in chat or in the Q&A. Another example that kind of mixes the discretionary issues and these more just basic logistical issues is the MIDAS system, which people might be familiar with in Michigan, which is an unemployment. So they implemented a system for unemployment fraud determinations. And this system falsely accused like tens of thousands of people of fraud, garnished their wages and their tax refunds. And it was rooted in kind of a combination of the choices they made about what were measurements, what were indicators of fraud. So they flagged any kind of discrepancy of data as fraud. They averaged people's income, but then if there was any difference between reported income and what they had come up with as the average, they flagged it as fraud. They also only sent notices through an online portal that if you were no longer getting benefits, you wouldn't necessarily log into. They didn't mail them, they didn't email them, they didn't call you. So this was a combination of bad technology design and these kind of discretionary decisions. And so I think from a data collection point of view, it's just important to note that sometimes there's this kind of algorithmic decision making, and that's really where the harm is coming from, that proxies for race are ending up affecting people's access, or proxies for other things, or just these kind of punitive and limited systems. But also sometimes there's just basic data collection that goes wrong and cuts people off from benefits. And both of those are important because sometimes we might want to fix a system and just make an online application actually work. Other times we might want to contest the basis of the decisions and the types of data that are being used and how it's being analyzed.
Thank you. That's a really in-depth answer. I want to ask Tina Tina, in your role, you do see how public agencies are collecting and using this data from other benefits recipients. And I think Emily has gone a little bit into the kinds of data sources and the kinds of ways that these tools make decisions. I was wondering if you've heard if there's any additional information you can add to that, or if there are clarifying information about the agency responses you've received about why these systems are collecting data and how it's used.
Sure. Thank you. Thank you for allowing me to participate in this panel. this information, especially on this day that you identified as the data privacy collection day, is really appropriate. So in the DC area, we have obviously the DC Medicaid system in which individuals can apply for benefits through the Medicaid program to receive in-home personal care aid services through the DC Medicaid program. Those individuals are assessed by a contractor with the district called Liberty Healthcare, and they send nurse assessors to the individuals' homes to conduct these assessments. And within that process, there is a ton of data that is collected from the individual. The data that is collected pretty much falls into about 8 different categories. Some of the categories include socio-demographic and identifying information, data such as your name, your address, your gender, your ethnicity, your race, your marital status, your living status and arrangement, even your payment source, whether you're going to be self-pay, private pay, or paid by Medicare or Medicaid. There's also a category for cognitive issues. So they collect data about your memory, your mental functional capacity, the level of assistance you need, and your ability to make decisions. There's another category of data that's collected in terms of communication and vision. So how you express yourself, how you understand information from other people, whether you have issues with your hearing or with your sight, that data is also collected. Then there's data that's collected in mood and behavior. So they determine whether or not the beneficiary or the applicant has depression or anxiety or problems with social interaction or wandering or even elder abuse or other concerning behaviors. And then there's another category of data that is collected on the psychosocial well-being. So questions related to your relationship with others and the social activity that the beneficiary may be engaged in. Another category of data collected is the functional assessment. So those are questions that get to your ADLs or activities of daily living and your instrumental activities of daily living, the IADLs, such as eating and bathing, dressing and toileting and transferring and walking. Those are the ADLs. And for the IADLs, meal prep, housework, managing your finances, managing your medication, even shopping and transportation. And then there's other data that's collected in another category for diseases and health conditions, treatments and skilled care needs, such as nutrition, medications, medical treatments, psychiatric diseases, whether decline is a fall risk. And then the last category is social supports and environmental assessments. So your family situation and other people who are available to assist you. So this is a lot of information that beneficiaries and applicants to the DC Medicaid program are asked and expected to provide this information to determine whether or not they are eligible to receive the services. And of all of those categories, remember I said there were 8 of them, there are only about 2 and maybe a half of one category that actually go into the determination of whether or not a person meets the nursing home level of care to qualify for, in DC, what we call the Elderly and Persons with Physical Disabilities Waiver Program, to receive the in-home services through personal care aides from Home Health Agency. And so there's a whole slew of information that's collected that does not go into whether or not the person meets the level of care to qualify for the program, or whether or not the person meets a level that will spit out through an algorithm determination the number of PCA or personal care aid hours that a person might be awarded under this program. And so we've seen a lot of data being collected from beneficiaries, data that is not being used towards whether or not they're even eligible for the program. And so we often wonder what is going on with the collection of this extra data that is being collected, since it's not being used for the purpose of determining a person's eligibility for the DC Medicaid program. In addition to having questions about what's going on with the data that's being collected, we've also had questions about whether or not the data that is being collected and being put through this algorithm is actually determining the correct amount of benefits that a person should be entitled and is entitled to receive based upon their physical disabilities. And we have seen in LCE that most of the time, the number of PCA hours that the person is calculated through this algorithm is incorrect. That it is not actually providing the number of personal care aid service hours that a person needs in order to meet their daily needs. And this is having a great impact on us in the district. And we are often filing cases for fair hearings at the Office of Administrative Hearings Office to challenge these algorithm generated service hours for clients who may need up to 24 hours of care, but your algorithm has calculated that the person only needs 12. And so that's an issue that we have seen in the district as well. And every time that we have taken these cases to court, the judges agree with us that the algorithm does not clearly paint all of the needs that the beneficiary needs in terms of their services and supports. And it's because they're using, I will say objective, I'll put objectives in quotes, objective information and not relying on subjective real life measures through conversations and connections with the beneficiaries that actually end up with a result that actually reflects the need of the individual. And for the extra data that's being collected, we have asked the district, what is this extra data being used for? And we have gotten a variety of answers from no information to a little information, but allegedly what that extra data is being used for is to assist with the person's person-centered service plan and also to connect people, the beneficiaries, with other government services such as housing or money for home repairs. But unfortunately, we have not seen that that has been the case. Mostly because there's a lack of coordination between the DC government agencies that the beneficiaries in which they would qualify for these other types of services as well. And one of the things that we have also pushed back on or questioned with the Department of Healthcare Finance, which is the DC government agency that runs the DC Medicaid program, is, in addition to all of this data that you're collecting and what are you doing with it, we are concerned that some of the data that's being collected is actually being used against the beneficiary, such as one of the things that they said that they collect is information or data on the utilization rates of their services. So if people are not accessing services such as homemaker services or adult daycare programs, then the government is actually using the low utilization rates as a basis to cut the program. Many of which are underutilized because either people don't know about those programs because the district does not do a fantastic job in educating people about these programs and sharing people how to access these services. And so that may be why it's underutilized, but they're using the data again, saying that people are not using these programs as a reason to cut those programs. So those are just some of the issues that we have seen in DC in terms of the data that's being collected from beneficiaries who are either applying for the Medicaid program or they are, up for reassessment so that their services can continue. And piggybacking on something that was said previously in terms of Social Security Administration, not only do we see clients who run into problems when Social Security looks at their bank accounts to see, what money is there at the beginning of the month. We've also seen instances where the Social Security Administration has, in our view, trolled real property databases. And that has had a negative impact on our clients as well, especially clients who receive SSI because they are then considered over assets if the Social Security Administration discovers that the client owns property, but they don't really go through the through the course of trying to figure out whether the property is really owned by the beneficiary, whether it's family property, whether it's property that the beneficiary could even access for it to be a real asset, whether the property is in another country. So those are all the kinds of questions and issues that also arise when other government agencies look at other data from other federal agencies to determine eligibility for particular programs.
Thank you. On the topic of services, more explicitly, I want to hone in and talk about treatments and the services that we think about with what you're describing. And so I want to, I believe it's the 21st Century Cures Act from 2016 that mandates that all states implement electronic visit verification for all Medicaid personal care services and home health services. So Lydia, I'd like to ask you, how does this electronic visit verification work, and what kind of restrictions does it impose on workers and recipients? What impact does it have on their lives?
This is Lydia. Thank you for that question. I'm a youngish East Asian person with short black hair, wearing a dark shirt and dark jacket today. My pronouns are they, them, and my sign name is L. Brown. The 2016 21st Century Cures Act required that all states had to implement EVV systems by 2021. And for some types of services, that deadline has extended to 2023. And those systems were intended to address the problem of fraud, which has long been a concern of policymakers who are setting policies that affect the lives of millions of people, usually from marginalized communities. The idea that people who are poor, disabled, from communities of color, or who need access to any form of social services or public assistance in any way should be considered presumptively engaged in fraudulent or dishonest activities is also rooted in a long history of societal policies engineering eugenicist concepts that only certain people deserve to have access to services, and that if you are receiving some kind of publicly funded service, then you need to prove that you are sufficiently deserving of access to that service. And electronic visit verification on its face, like many such policies, purports to be neutral. It's simply a means for people who are providing direct care services, like helping somebody to dress or take their medication or eat or be transported from one part of the community to another part of the community, to log that they are in fact who they say they are, that they are providing the service that they say they are providing, and that they're doing the service at the time and the place where they are supposed to be providing the service. And if we just take that, just at a superficial level, that doesn't really sound particularly scary or concerning, right? Like, we want to know that people are doing the jobs that they're supposed to be doing. That doesn't sound particularly onerous. But the problem with electronic visit verification systems is that they in fact compose an extreme level of intrusion into the privacy and the dignity and the autonomy of both the people who are receiving care and services and the workers who are providing that care and those services, many of whom also are often immigrant women of color, and many of whom are often disabled themselves. Those systems require providers to log information about where the services have begun and when they have ended, where they are located while providing the services, and who they are, as well as who the person receiving the services is. But because it's embedded in the name, the system does not accept, for example, a simple timesheet or a signed piece of paper that says, I agree and confirm and attest that my care worker provided services in this way as approved as they're supposed to be doing. Instead, some form of software tied to a landline or GPS-enabled software on somebody's phone or a tablet has to actually verify in real time, often with geolocation services, that the worker is in fact at that precise location. Different providers and different software systems use EVV that has a range of functionalities, as each state is allowed to determine the way in which they will roll out their EVV program. Some require a worker to actually log a separate entry for every individual task they perform. Think about that. You're a disabled person, whether you have Down syndrome or cerebral palsy, or you are a quadriplegic, and you are requesting that your support worker perform a range of tasks, including opening the door for you, unloading your groceries, helping you change clothing 3 times for 3 different reasons, like non-disabled people change on a whim, prepare your food, give it to you, make sure that you take medication that you need assistance with. Perhaps they will assist you by supporting you as you travel from where you live to a place you volunteer or have a job or to see a friend or participate in a protest or whatever it is that you are deciding to do, COVID aside. Your worker has to stop between every one of those tasks to log in to a software program to verify what task they are about to perform. And then when they have finished, what task they have just finished performing. Which, again, think about it, cuts into every available minute that they had to be providing that service to you to begin with. Now, I've also talked to some of my friends and community members who are forced to use EVV systems because they are receiving Medicaid-funded services or they are working in a job where they are providing Medicaid-funded services for another disabled person. And one told me that if they make an error, any error in the system, their employer, who is in this case the disabled person who is self-directing their services, meaning that Medicaid has given them the money to be able to manage who their care workers are, but they still have to comply with EVV requirements. Their employer, the disabled person who needs services, has to go in and manually correct every single error that might have occurred because the worker is not allowed to make any edits whatsoever to the information that they have provided to the system. Now, that sounds like a nightmare to me and my ADD, but it's also a nightmare for the millions of disabled people and workers who are forced to use these types of programs because not everybody has access to a landline or a smart device that can use a particular piece of software or broadband internet connection that supports the use of that device. Not everybody has the time or the wherewithal or the energy to log everything that they're doing. And not everybody has the privilege of being able to stay in the same location for the receipt of services. Because most EVV systems require that the start and end of services has to be logged at the disabled person's home. And while states are not required to limit every possible location that a disabled person and their support worker might go to in the course of receiving services, functionally, some EVV systems may limit disabled people and their workers from being able to go literally anywhere because it might be registered as fraud by the automated system should the electronic visit verification capture geolocation data placing a disabled person and their worker at, like, I don't know, a convenience store, their local synagogue, at a friend's house, especially if the friend is also disabled and perhaps receiving services. And we can see how these technologies of surveillance over both disabled people needing care, who by definition are subject to income and asset caps that enforce poverty, and workers who are often working under terribly paid and compensated conditions without adequate labor protections, to be surveilled and monitored for fear by policymakers that the people who have the least access to resources and support are the most likely to be engaging in fraud. And that algorithmic surveillance and that means of monitoring and control is simply an expansion of and an extension of similar technologies of surveillance and carcerality in a variety of other contexts, predominantly affecting disabled folks and other folks at the margins of the margins.
Thank you, Lydia, for that. I want to talk a little more actually, about employment. It's not something we've touched on, but you did mention algorithmic surveillance. This question is for Damien. Damien, could you tell us a little bit about workplace technologies and how they've changed? And we're in the time of Zoom now. So what kind of new data can employers obtain about their workers? What kind of technologies do they use that we may not be aware of? And what do they get wrong about tracking performance and productivity of the workforce?
Thank you for that, and thank you for that question. This is Damien. I'm a 39-year-old Black man. I have curly natural hair that is shaved on the sides and long in the middle. I have facial hair and glasses. I'm wearing a dark suit, a dark shirt, and a purple paisley tie. I want to especially thank Lydia for the discussion about the workers who do the work at the margins, as well as those of us who are subject to the surveillance under the constant monitoring of the state to achieve and receive benefits. That electronic visit verification work limitation is one form of the kind of surveillance and bossware systems that we see at play in the lives of workers on the whole, right? Like it is an egregious example of something that has become extremely pervasive in our daily lives. And as you said, Nasser, we have the kind of the Zoom era, right? We have the idea of everybody is accessible all the time, not just because of our email, but because we also have access to each other's Zoom rooms, or we should be available via Slack message, or we should be available via text because we can't go into the office, or we should go into the office. So we have to be available on the fly is the usual justification for these things. And what this translates to is employers being monitored via things like their Teams uptime, like Microsoft Teams. It has the indicator light as to whether you are busy or whether you are active or whether you are idle. And if you are not active or busy, that monitoring of that, I know there have been reports of people who have been monitored and reprimanded for having let their Microsoft Teams uptime go idle. That's basically just the awareness of every so often while you're in the middle of something else that you're doing, you have to go in to Microsoft Teams and click around to make it look like you are busy there, even if you are in the middle of other work. There's the pervasive use of time clock monitoring and the monitoring of how much time people are actually spending on the clock, how much time they're spending on break, how much time they are actually using to get to and from the work that they're doing if they do have to go on site or have to be in person for other things. And then there's the use of general monitoring and surveillance software that tracks the behavior of a person on work supplied tools such as laptops and cell phones that monitors the usage and the behavior of the employee. All of these things can be and have been, in many cases, cross-referenced to create a larger system and network of data to compare against what employees say they need in terms of the amount of time they have to work versus the actual clocked time, a situation which doesn't take into account the lives of disabled people who need extra time to get to and from, to need extra time to prepare themselves for their day, people who have need of more preparation in general. The time that they need is not factored into these conditions on time clocks, on monitored behavior, on the expectations of how they will behave in their day. In the workplace, we have the use of ID tracking, swipe card tracking, biometric feature tracking, log into break rooms to tell exactly how much time each employee has spent in a break room versus at their desk, swiping in and out of certain areas to control against exactly how much time they said they needed for a break versus how much time they took for a break. This happens in the education context as well. Students monitored for their food hall usage and the time that they spend in their dorms with magnetic swipe keys that are attached to their student ID cards. We have in warehouse settings, we have the tracking of uptime and the efficiency of workers, right, by handheld devices that they use to scan orders in and out to go through and fulfill orders that have been brought in. This happens not just in places like Amazon warehouses, it also happens at places like grocery stores, with the increasing rise in curbside pickup for grocery stores like Kroger and Safeway. Every curbside pickup worker has a handheld scanner, and they have a clock that starts as soon as the customer logs in as having arrived at a particular numbered spot in the parking lot. And from that period, from that moment, depending on the store, I know for Kroger, it's from that moment, they have 5 minutes to gather all of those groceries, leave the curbside pickup office, which is a separate office from the rest of the store. It's its own little specific space so that they can have more time and directed resources to make use of, just picking up these groceries. But they have 5 minutes to gather those things, to leave that space, to get to the parking lot, to deliver those groceries to the customer, and to use the handheld device to read as having completed that order. This is why there is a particularly limited number of windows for any given hour if you order curbside pickup online, because that is the amount of time that system and those who have designed that system, developed that system, have determined the optimal amount of time and the optimal number of orders can be filled within that space of time. So all of these things are used to track worker efficiency. They're used to track worker needs, to correlate breaks, to determine rates of pay. But all of these things are metrics that are used to hit a target, and they're idealized, they're oversimplified. They don't actually account for things like, well, today it's raining ice outside, and it's going to take somebody a little bit longer to get through the parking lot, to navigate the parking lot. It's 4 o'clock in the afternoon on a Friday. So what point are they going to have to deal with the vast number of people who have decided to come through the parking lot at high speeds, having just picked their kids up from school? How much more time and more effort is that going to take them? Your workforce is in decline because more people are sick. How many more orders and how many fewer orders can you handle when you have half the workforce that you used to have? But all of these metrics they're trailing indicators, right? They're used not at the outset to understand what might need to be given to employees, rather they are used to determine what the employees must do to meet marks. They are given as restrictions and as controls. These tools don't increase security. They don't increase efficiency. In fact, they decrease the health and the efficiency of workers on the whole, since increasing the amount of work and decreasing the amount of time that these workers have, orders have been increasingly wrong, right? Curbside pickup orders, pre-prepared orders by the store have been in error more often. And if you have somebody who is already under stress and already under pressure, and this is their first job, and they're like, 18 to 25 years old, they're doing the best that they absolutely can. If you're like me, you're not going to want to complain about that person in that job, because you know that all that's going to do is get that person fired. It's not going to lead to a change in the system that puts too much work onto them, that places too many expectations onto them, that uses erroneous fittings of data and an automated system of idealized timing metrics to say, well, they should have X, Y, and Z amount of orders to be able to be filled in that time. And if they can't do it, then they're not getting the job done, so they're fired. All of these things decrease systems like morale, and they can lead to increased anxiety and decreased worker health and overall mental health. Overarchingly, this again feeds into things like not just employment, but also into insurance and into education. And we see all of these things resonate across all of these things. Additionally, people will at a certain point just quit, because being monitored in this way, overarchingly, the increased anxiety, the increased pain, the increased hassle, the increased hours, and no increase in wages, no increase in compensation, eventually that will overbalance, and the cost to benefit ratio will no longer be in the favor of that worker retaining that job.
Thank you, Damien. Hearing about how workplaces are creating surveillance ecosystems to monitor productivity, throughput, and efficiency really makes me wonder about the resilient and frankly remarkable students in classrooms today and how they're striving to meet educational attainment goals set by public and private institutions. I wonder, with this forced transformation to digital teaching methods, Lydia, could you tell us a little bit about new data that might be collected inside and outside of school? What technologies they might be using and what effect this has in particular on marginalized students and on students with disability?
This is Lydia. In the age that we live in now, especially because of the pandemic, technology is endemic and pervasive in literally every aspect of our lives, and especially for our young students. And this is true whether we're talking about education in the K-12 context or whether we're talking about education in the higher education context. From remote proctoring tools that automatically flag whether or not students are engaging in suspicious behavior to social media monitoring, especially on school-issued devices. Students are subjected to a greater level of technological intrusion and surveillance now than they might have ever been before. And some of these technologies have represented an outgrowth of policies after the Columbine school shooting to attempt to harden schools and to increase surveillance of students ostensibly for public safety goals, not just to allegedly prevent mass shooting events or other acts of violence, but also to address issues of school climate, like widespread bullying, including bullying of students from marginalized communities, like bullying students from immigrant backgrounds, from minoritized faith communities, or who are LGBTQ. But such public safety measures also might include as ostensible goals attempting to promote students' positive engagement with the school, to address potential concerns around student suicidality or self-harming, and any manner of other goals that, for the most part, most people would probably think of as pretty reasonable. In the same way that we were talking, a little while ago about EVV, that most people might think it's pretty reasonable to want to make sure that people are doing the job that they're supposed to be doing. It might sound reasonable that we maybe want to stop bullying, that we maybe want to prevent violence from taking place at schools, and that we probably want to prevent students from acting on suicidal ideation. But unfortunately, technologies that automatically analyze students' content, the content of their web searches, the content of messages they exchange, the content of social media posts that they make, software that might analyze the ways in which students are interacting with their school environment, how much attention they are paying to online course modules, similar software that might track that activity as is deployed in the workers context that Damien was just talking about a couple of minutes ago, can actually end up having the opposite of the intended effect by making schools less safe, by focusing attention or disciplinary consequences on activity or behavior that don't necessarily amount to problems, and by reinforcing and perpetuating existing patterns of racial, gender, and disability-based discrimination that lead to disproportionate numbers of students who are Black and brown, who are queer and trans, and who are disabled, facing sanctions ranging from suspensions and expulsions to placement on academic probation or referral to the criminal legal system. I say this not lightly, but to acknowledge that just as when we talk about predictive policing technologies, their expansion and deployment can reinforce and can perpetuate existing inequalities, that very same pattern will take place and often has taken place in schools, where suspensions and expulsions are documented to occur in the highest numbers or percentages in students when teachers and other school administrators may be granted the technological capacity to listen to automatic recordings of students' voices or to noises in corridors through technologies that purport to expand and to promote school safety by listening to the sounds for anger or for violence, that will actually have the unintended effect, but and affected as a result of design in a profoundly biased, racist, and ableist society, of being more likely to single out noises and language and words that might be innocuous or might be more likely to come from students of color, from LGBTQ students or students of disabilities, whose voices, whose words, or whose content online may not be accurately interpreted, may not be understood within its cultural context, and will be more likely to lead to adverse disciplinary determinations from school personnel who are already bringing their existing biases to review of technologically flagged content or activities occurring in a school environment. Lastly, I would be remiss if I were not acknowledging the expansion of such surveillance technologies to expand or to accelerate the use of risk assessment, which is a process that is meant to address whether or not a particular student's behavior or speech are actually likely to pose the possibility of the risk of violent or other concerning behavior, but in reality has been shown to have a detrimental effect and one that is disproportionately detrimental on students of disabilities and from other marginalized communities, who will be more likely to be reported as potentially suspicious or concerning by both their peers and by school personnel, and therefore more likely to be subjected to intrusive and sometimes coercive requirements that don't actually promote school safety, but will make already marginalized students feel less connected to their schools, less supported by their schools, and preemptively profiled, judged, and criminalized.
Thank you, Lydia. I want to revisit the topic of predictive policing in particular that Lydia just brought up. And we often hear about how technology further facilitates types of surveillance that were not possible before. Predictive policing being the product of mass data collection systems. I wonder, Emily, if you could tell us a little bit about how law enforcement surveillance practices cause people with disability in particular to be targeted and how they are most affected by these systems.
Yes, thanks. This is Emily. Yeah, and building on what Lydia was just talking about, a lot of this surveillance in schools criminalizes youth and involves partnerships with law enforcement and data sharing and school cops themselves, like social media monitoring tools. Another example we've been looking at recently in DC is the gang database, where until recently, school police officers could add youth to the gang database based on things that they were wearing, pictures they saw, people with supposed gang members, conflicts in school that got kids labeled as gang members and targeted. So there's a lot of connection there. I think it's important just to say, surveillance is always about power, and surveillance used by policing always is for the purpose of expanding police power, expanding their ability to target people, to punish people, to incarcerate people. So that's any surveillance tools are going to be used for that. And policing also has its roots in targeting Black people, targeting disabled people, targeting other people of color, targeting anyone who deviates from kind of like a white middle upper class, non-disabled, productive worker, et cetera, all these norms, right? And a couple things I wanted to share. So T.L. Lewis writes about this and compiled these statistics in an article that I will link in a moment, but just to show some of that disproportionate targeting. So disabled and neurodivergent people comprise just 26% of the US population, but represent up to half of the people killed by police, over 50% of incarcerated adults, up to 85% of incarcerated youth. And then there's also institutionalization in the context of people who are unable to get the care they need in their home and are forced into nursing facilities and other institutions. So that's an important context. And also I think another important historical context is roots of policing in our country in slave patrols, and the fact that there were actual psychiatric diagnoses where enslaved people who wanted to run away or who ran away or who resisted in any way were actually diagnosed with formal psychiatric disorders. And so there's just a lot in terms of the idea of our carceral system enforcing these norms of how it's acceptable to behave or exist, and punishing people who deviate from that. I think concretely, there's certain kinds of surveillance, especially some that are a little more emergent that could, just in the functioning of the technology itself, especially target disabled people. So some of the things around like affect and emotion sentiment analysis, again, ways of very discretionarily trying to measure people's adherence to some kind of norm. And then the other thing that I'm happy to talk if people have questions about any other specific surveillance tech in the chat or in the follow-up. The other thing that I actually really wanted to mention is this kind of tension in our system where in order to get benefits, you need to make yourself visible to the state, but there's also a lot of risks of making yourself visible to the state. And especially if you're Black, if you're disabled, if you're trans, if you're undocumented, if you're any kind of identity or combination of identities that is already targeted by the state. So one very like stark particular example of this is that a lot of our benefits programs actually, you are not eligible for them if you have a criminal conviction, if you have any kind of criminal record. So we deny people like basic needs like food and housing based on that. And Michigan had a system for, or has, I'm not sure the current status, for SNAP, so food stamp eligibility. And it actually looked people up against a felony warrant database and denied people benefits if they found any kind of match in this felony warrant database. And there are a lot of problems with that. First of all, the policy problem I already named, that you shouldn't be denied food because even if you have, committed a crime, as it's defined by, again, this system that is categorizing what behavior is acceptable and individualizing systemic problems. But also it was a felony warrant database, meaning these aren't even convictions. Also, it was rife with errors where people's name either was mismatched or their identity was stolen and used to do something. And for example, one woman had to drive to a town she'd never been to, turn herself into the police and spend a night in jail for a bounce check that she never wrote just to clear her record so that she could get SNAP benefits. So that's just one example of how these systems intersect and how data sharing across law enforcement and schools and benefits programs can really exacerbate these harms. And I'll stop there for now, but again, yeah, happy to talk about any other surveillance technology stuff and questions.
Thank you. I want to go a little bit into the ways that these tools really can determine access to healthcare a little more. Damien, I wanted to give you the opportunity to talk a little bit about that. Would you be able to just tell us a little more, if possible, about how targeted surveillance affects the actual explicit data that's used to determine the access to healthcare itself and other benefits?
Yeah, I mean, there's a couple of ways. Emily listed a couple of them in terms of things like SNAP benefits, but also in terms of Social Security disability benefits here in the U.S., but also in the U.K. Facial recognition being used on protesters who were protesting against incursions into disability laws and depredations and removal of opportunities for access to the National Health Service. Protesters were targeted and then were deemed not disabled enough because they had been apparently well enough to go out and protest. So they obviously didn't need their benefits anymore, and they had those benefits removed from them. The opportunity for the cross-referencing between insurance database systems, fitness trackers used by employers that then get cross-referenced with how people actually spend their time. Again, this notion of, are you still as disabled as you say you are? Everything that Lydia talked about in terms of electronic visit verification is this question of, if you are not deemed to be as disabled as the state thinks you are, or to act as disabled as the state thinks you ought to act, then you are then flagged for fraud, right? And a fraud referral within the criminal justice system can then, as Emily just said, remove your eligibility for benefits that you need to live. If you get a criminal fraud referral, if it's a felony referral, if you have this flagged on your record, if you have it flagged repeatedly because the error comes up again and again because the error persists across several different automated systems. It was never corrected in one place, and then it persisted in life across multiple data sets that were cross-referenced by multiple different systems that are interlocking that you depend on to live. It follows you. And if you get flagged once and then flagged again, flagged multiple times, then people will start to look at your needs, your requests for access, as fraudulent at base, fraudulent on their face, which then de facto excludes you from access to the benefits that you need to live your life. All of these things become tools by which the carceral system recommends against and measures against the notion of what a disabled person needs versus how they are expected to actually present themselves and live their life out in the world overall. And if those things don't match in the eyes of the state, in the eyes of those making the assumptions, or in the eyes of those building the systems based around the assumptions and expectations, then you are, again, de facto excluded. You are pushed out and you are potentially referred for criminal prosecution.
Thank you, Damien. Lydia, I want to pivot over to you and just go a little further into the relationship between health and policing. Can you talk a little bit about what social determinants might be used in these policing practices and how this relationship affects who is explicitly targeted by data-driven law enforcement?
This is Lydia. Data-driven law enforcement fundamentally operates in one of two ways when we're talking about predictive policing tools. Predictive policing tools that try to focus police resources and attention based on locations that may be designated as or predicted to be hotspots for crime, and predictive policing tools that try to allocate or focus police resources and attention to individual people who are considered to be likely to be engaged in criminal activity. And I think, or at least I hope, that we can contemplate very quickly how both of those approaches to trying to predict where police should go are inherently problematic and deeply concerning. When we already know that the criminal legal system disproportionately results in targeting people from marginalized communities, especially Black and Native people who are immigrants or from minoritized religious communities, and disabled people, among other categories of people who face higher rates of police surveillance, of arrest, and later of conviction and incarceration, then using predictive technologies to attempt to assess or evaluate what locations, what neighborhoods, what communities, or what individual people should be the targets or locus of police attention means that police will be paying even more attention to the very same communities and people that are already targeted for overcriminalization and surveillance. And when we think about, in a broader context, data-driven tools used in the criminal legal system for purposes other than just where police are going, but we're thinking about courts using risk assessment algorithms to determine pretrial release or bail. We're thinking about parole boards determining who should be considered for early release from incarceration and return to the community. And again, using perhaps the same type of risk assessment algorithm, then we're also thinking about the ways in which such algorithms are taught or programmed to evaluate what factors in a person's life or community might make a person to be considered more of a risk or less of a risk. And those factors are often tied to the same kinds of experiences or characteristics that are more likely to occur in marginalized communities, whether for disabled people or other marginalized people. For example, do you have family support? Well, people with disabilities face higher rates of domestic violence and intimate partner violence. Many disabled people come from and many people with disabilities who seek out partners and who have children face intrusive court surveillance and intervention by child welfare agencies that is often predicated on ableist assumptions that disabled people cannot be fit parents. And so if you're assessing how much family support and family connections a person has in determining what their level of risk is for recidivism upon release, then people with disabilities are less likely to have a higher score on that marker. When tools might consider what level of education someone has, well, people with disabilities face extreme discrimination in education, in both the K to 12 system and in higher education, and so are less likely to have completed a high school diploma and less likely to have completed a college degree. If you're looking at steady employment, people with disabilities every year, according to the Bureau of Labor Statistics, face a higher unemployment rate than non-disabled people. And so disabled people are less likely to have steady employment that can prove that this person is less of a risk and more likely to be connected to the community. If you look again in a very cyclical way at what is a person's prior record, someone who has faced any arrest in the past, regardless of the reason for the arrest or whether or not the arrest was accurate as to the person's actual actions, then people with disabilities and other marginalized folks who come from communities that face higher rates of policing and criminalization are going to be more likely to have some kind of prior record that will be used against you in that assessment process. So no matter what kinds of tools we're talking about to apply data-driven practices to determine what police should be paying attention to, or what people courts should be considering as less or more risky, or who should be offered the opportunity to return home from incarceration, communities that have already faced hyper-surveillance and hyper-criminalization will remain at risk for amplification, exacerbation, and acceleration of those practices.
Thank you. At this time, I just want to let everybody know that you do have the ability to please send everybody a question. If you have a question for anyone in particular, I'd be more than happy to read it out loud, but please don't be shy. The chat is available to you. Now, surveillance, these data-driven law enforcement practices, these things play significant roles in whether people can access any benefits and they're able to meet their health needs appropriately, as Lydia just went into explaining to us. I want to ask you, Tina, if you could tell us with this surveillance, what are the wider impacts on other areas of recipients' lives due to these surveillance practices?
Well, interestingly enough, I think it was Damien brought up the issue of fraud. Prior to 2018, in terms of determining whether a beneficiary was qualified for waiver services to receive the in-home health care, it was a much more subjective system. And because there was fraud in the system, not fraud being committed by the beneficiary, but actually fraud being committed by various home health agencies, that's when a new system was instituted in DC, and they created this whole new algorithm system in order to determine whether or not you were eligible for benefits. So fraud did actually play a role, but it had a negative impact on the beneficiaries themselves, even though they were not the ones that were allegedly or found to be committing the fraud themselves. But in terms of how the surveillance of this data is being collected is impacting folks generally, we have seen that the data that's been collected through this assessment program has really caused some of our clients or some beneficiaries or applicants to be denied services at all. So that is actually forcing people who are disabled, who do need services and supports, to go into nursing homes because they can't qualify for the waiver program, but yet they need the services and supports to be able to live. And so they have to go into a nursing home. And unfortunately, in the DC area, many of our nursing homes are at full capacity. And so some of the beneficiaries then have to find nursing home placements, if they can, in Virginia or Maryland, because there are no beds available in DC. And so you see then having a senior being displaced from the community where they grew up, where they have other services and supports, where they have neighbors who normally would have checked in on them. They don't have those services and supports anymore because they're in a whole strange new jurisdiction where they don't know anyone. So that's also then has a detrimental impact on their health, because we know statistics have shown that when seniors are displaced out of their community, then their health declines. And so they decline quicker, and it leads to death. And we have seen many, unfortunately, of our seniors who have been forced to either move to Maryland or DC because there was not a home available, or because of the algorithm that determined the number of PCA hours they were eligible to receive did not give them the appropriate number of hours that they actually needed. They have died. So that's the most extreme situation that we've seen. It actually has caused death, and it also has resulted in people being denied the services and supports that they need. One other way that we see that it impacting people is some of our clients have, even though they may qualify for the Medicaid program, they meet the level of care, they have an appropriate number of personal care aid services that have been determined. If they have had issues in the past with home health agencies, and that data is collected and shared among home health agencies, whether the issues have been with the beneficiary themselves or with maybe a power of attorney agent or family member, that negative data that has been placed in the system will have a negative impact on the person trying to receive services, because there's another home health agency that has access to that data, and therefore they don't want to take on that person as a client. And so again, it leaves someone vulnerable who started out vulnerable, even in a more vulnerable situation, when they can't find someone who will actually take them on as a client and provide them with the services and supports that they need. And also, if we have data being collected, which we do, on the interaction between the beneficiaries and their aides, and if for some reason a beneficiary decides, because of their own cultural preferences, that they would like an aide that may be a male, or they may want an aide that's a female, and so they refuse to accept an aide from a home health agency that does not align with what they want in their person-centered care plan, that information is being used against them at their next assessment as well. So there are lots of negative impacts that this data that is being collected from about our beneficiaries and applicants as they go through this process, that has had a larger impact on their lives in general.
Thank you, Tina, for that. We have an audience question that we'll pivot to, and this question's for the panel. So please feel free to jump in however you feel, if you can answer it. So what are some of the processes for redress for the excessive and discriminatory intent / impact of the surveillance, artificial intelligence, data systems you all have described under both federal and state law? What avenues are available / effective outside of resorting to litigation? This is open to everybody.
This is Damien. I'll jump in and say that in many of the cases of the systems that we've been talking about, the awareness of the system's data sets and operating programs and models, the algorithms that are used to model this prediction and make these determinations, in many cases, they've only been learned about after lawsuits. They've had to be sued to, like, the systems administrators have had to be sued for access. And in many cases, those administrators are the states in question. The state of Michigan, the state of Utah, the state of Idaho. They've had to be sued to gain an access to these systems and to the way that the data was being manipulated, the actual frameworks and the determinations that are being used. And so that at present tends to be the first avenue of redress that's available, is to sue for access, to demand, because in many cases, just simple Freedom of Information Act requests have not been enough. They've been held close under proprietary secrets, and called, told that if they were allowed to be known, that I'm missing a word here, the potential revenue for the private companies that administer these systems could be negatively impacted, right? when what the countersuit has had to say in these cases is this is stuff that affects people's lives and it's being administered in a public setting. this is literally life and death stuff, and somebody lost benefits and they don't know why, and they don't have access to the data that could tell them why. Everything according to their eye that they told the system was the same as it had been. So why did it change? Why did the determination change? In terms of avenues available outside of that, we don't know yet because we haven't really gotten that far. Like, policy changes are a major potential avenue, and that's what a lot of us are all working towards and pushing for. Those of us here working today, public organizing and getting people together to do that work and raise awareness about it is something that can really help to get these things changed.
I will add that prior to us at LCE filing complaints or for fair hearings with regard to these cases that we were seeing, we did open the door to try and have conversation of policy changes with the DC government agency that oversees the program. And they were amenable to having conversations and discussions with us. And we actually, for about a year or so, actually had monthly meetings with the staff, the government staff, and we were able to point out to them all of the problems that were being experienced by the beneficiaries and applicants for the program. And they were receptive to some of them, of the issues that we brought to their attention. And they did, as a way of addressing some of the issues, go back and decide maybe we need to retrain these nurse assessors on how to better conduct the assessments, how to better have communication with the beneficiaries, because we understand that even if there is an algorithm that's spitting out a particular result, the result that it spits out is only as good as the data that is input. And so that required them to go back and have extra training with Liberty about, again, how to better conduct these assessments, how to ask more subjective questions, how to ask follow-up questions, and suggesting that some training might resolve some of the problems that we encountered. And actually it did, but we obviously continue to press forward with our litigation measures, but opening up that conversation, having that dialogue did have, at least initially, some impact on and some changes.
Thank you. I wanted to give the other panelists, if they had anything they'd like to say, please feel free to jump in. Otherwise, I can move to the next question. Go ahead.
Yeah. One thing that we have seen, and my colleague Matt Scherer at CDT has written about, is that in the context of worker surveillance, which Damien had talked about at length earlier today, that the Americans with Disabilities Act actually might pose some of the strongest protections for workers who are affected by algorithmic monitoring and workflow management, in that people with disabilities that are negatively affected, that cannot be accommodated by, or that are exacerbated, leading to further illness or injury that can become additionally disabling, may have the ability to ask employers to actually account for their disabilities by following the reasonable accommodations and interactive process required under Title I of the ADA. And unfortunately, those protections do not extend to workers who are not currently disabled. And one of the biggest harms of worker surveillance technologies is the possibility of causing or exacerbating disabilities. If a person didn't have a disability before the warehouse tracking software forced them to work at an untenable pace, they might have a disability later when their spine stops working right, or when they develop a permanent injury in their arms or legs or waist. A person who didn't have a disability before their sales call manager forced them to be followed and listened to by an algorithmic monitoring software might develop an anxiety or panic disorder after several months, let alone years, of being subjected to that treatment, to that surveillance. But the ADA does not apply to people who are not currently disabled. It only applies to workers once they have become disabled. And so, of course, that leaves a major enforcement gap, given that OSHA, the Occupational Safety and Health Administration, really does have limited powers and resources available for enforcement activity.
Thank you. Damien, I wanted to jump back to you there. With the audience question, you were describing how public institutions use these private tools and how knowledge of these tools is not easily discovered, except, through discovery. But I wonder a little more about commercially available tools. So could you tell us a little bit about these apps and tools that I may find on my phone that are not directly related to health? What kind of health data exposure do people with disability experience through using these that we may not know about?
Yeah, this is Damien, and that's a very good question, because there are a number of things that we don't often think about as being directly about our health, but which can be extrapolated and correlated to facts about our health. Things like even just movement and how much time we spend moving around the house that can be accessed by third-party apps, but also purchasing apps. Apps that you use for creating a pickup order or scrolling more easily on Target or Walmart or your local grocery store chain, right? All of these things retain the data that you input into them, and they use that to build a profile on you that they then use to more perfectly serve you ads and coupons and things that they hope that you will then buy from them. All of that can then be correlated against the certain types of things that it indicates. There's a very famous case in which Target's coupon, like home coupon services, sent a young woman a set of coupons about neonatal vitamins and baby formula and other things for a newborn. She was in her late teens. She lived at home. And they sent this to her because of the things that she had been scrolling and clicking and reading on the Target website. This gets sent to her home, and her parents have some serious questions. She herself starts to have some serious questions. So these kinds of things can be then, used and accessed by the apps that you give, direct access to. When you click the terms and conditions and you say you grant permissions for these apps on your phone, but also in most of those terms and conditions, you're agreeing to the sharing of all of that data with designated third-party partners of whichever corporation you happen to be doing direct business with. And then all of that becomes something that puts your personal experience, your lived experience, your needs, and your state of health out into the world to be correlated against and dug into by people that you have no direct knowledge of. So that is out there in the world. I also want to kind of circle back for a second. One of the things that we've talked about a lot today is all of the different metrics that get used to judge levels of disability and judge levels of care for disabled people and to make determinations about benefits, right? And one of the things that I think is really important to recognize is that in a large number of cases, the vast majority of these systems are dependent upon an idea about disability that is not current, is not verified against or developed out of direct conversation with the disabled community, right? These are ideas about levels of care and standards of care that come from the idea that your highest gold standard level of care is care in an institution, is care in a hospital setting, is care in a nursing home setting. And that the standard of care they're trying to get you, that you're trying to achieve in your in-home care, is a standard that matches that institutionalized setting. When Hasina was just saying a little while ago, the fact of the matter is the data all shows that when elders and disabled people have care in the community, when they are able to access in-home care, they do better long-term. And this has been known within the disabled community and within the elderly community for a very long time. But the standards that are used and the systems that are used to mete out benefits, to dispense benefits, is still a standard which says, no, the ideal situation for a disabled person is an institutional setting with doctors, rather than recognizing that, no, the actual ideal situation for a disabled person is the situation in which they feel cared for and comfortable, in which they can have something that cares for the whole of their health, not just the physical, medicalized aspects of their health. So I just wanted to like make sure that like everybody, because it's not, that fact isn't really widely known, right? We're sometimes talking about systems that are using an assumption about levels of care that dates back to the 1800s, you know, about what it means to be disabled. That is literally 19th century ideas of disability. And they're still being translated into 21st century disability tech. So we have to be aware of what it is we're even fighting against in the first place to try to get these things done and do the work we're all talking about doing.
Thank you for that, and thank you to all our panelists. It's been a good discussion, and I think I'll be giving the closing remarks. And so, to fulfill the purposes for which data-driven decision makings are implemented, it seems that we're all saying that they should only be informed by the data that speaks to whether people meet essential criteria without exploiting additional information collected for unnecessary or unjustifiable purposes. The criteria should also be examined. Entities using these practices should also consider who is defining or gets to define what this criteria is, or essential or even relevant, and establish mechanisms for questioning or challenging these criteria. In many cases, these inquiries can show that certain data practices should be significantly improved, if not entirely eliminated. Data-driven practices in any of the areas we discussed today, whether it was education, healthcare, workplace, and so on, can have extremely far-reaching ramifications in all of our lives, and especially the lives of those of people with disability. It affects how they're treated and the kinds of opportunities they have access to in all these disciplines. So data practices need to align with people's reasonable expectations of how their data will and should be used. And these practices should be part of the conversations when we talk about health policy and privacy. Thank you to our panelists and to everyone joining our discussion today. We'll leave our email addresses in the chat. And if you have any questions or would like to discuss further, please reach out. We hope you enjoy the rest of your day.
Thank you, everyone.